All right, so if you've ever watched a courtroom drama on TV, you've probably got this idea that a trial is just this total free-for-all, right? Where lawyers can attack every single thing a witness says. But the real world? Well, it's a whole lot more structured and honestly, way more interesting. Today, we are going to pull back the curtain on the surprising, hidden rules that dictate what actually happens in a courtroom, and how the system tries to balance this huge search for truth with just being practical. So let's just start with a big question that gets right to the heart of all this. In a real trial, can a lawyer really, truly challenge anything and everything a witness says up there on the stand? Can they just bring in a parade of other people to disprove every little detail? What do you think? The answer is, not exactly. See, unlike the kind of chaos you might see in a movie, the law has a very specific set of rules, and they're all designed to keep the trial focused. It is not a free-for-all. It's a structured process, and its main job is to stop the actual issue from getting totally buried under a mountain of distractions. Okay, let's get into it. First up, let's talk about this fascinating old rule that was basically a legal landmine for any lawyer who wasn't paying attention. It's a perfect example of how courtroom procedures can have some pretty serious hidden dangers. Okay, picture this trap. You're a lawyer, you're in the middle of a cross-examination, and you suspect the other side has a document that could be important. So you ask to see it. You call for the document, you inspect it, and boom, the trap is sprung. You see, under an old common law rule, just by looking at that document, you gave your opponent the right to force you to submit it as evidence. So if that document actually torpedoes your case, well, you just handed them the weapon. It was basically the you touch it, you buy it rule of evidence. A lawyer had to ask for a document at their own risk. Eventually, the legal system kind of looked at this and said, you know what? This isn't really fair. It could cause some serious problems, especially for a lawyer who had no clue what was actually in that document. And this is a great illustration of how the law isn't just stuck in the past. It changes, it evolves. This particular rule has been gotten rid of by modern laws to make the whole process a lot more just. So that was a rule from the history books. Now let's talk about a much more fundamental rule that is very much alive and well today. I like to call it the no endless side quests rule. Its entire purpose is to keep the trial focused on the main story, not a million little side stories. This right here is the finality rule. And in simple terms, it means that when a lawyer asks a witness a question about something that isn't central to the case, what the legal world calls a collateral fact, the lawyer is stuck with whatever answer they get. They can't then call another witness just to say, nope, that's not true. On that side issue, the witness's answer is considered final. So why? Why does this rule even exist? Well, like Baron Alderson pointed out centuries ago, without it, a trial could literally spiral on forever. Think about it. You challenge a witness on some minor point, then they get to call their own evidence to defend their answer, and then you get to cross-examine those witnesses about their credibility, and on and on and on. You'd be chasing these endless collateral issues and never get back to what the trial was actually about. Okay, so the whole thing really hinges on understanding what makes a fact collateral. What's the actual difference between a detail that's part of the main story versus one that's just a side story? Let's break that down. This is the perfect way to look at it. Let's say we have a car crash case. The question, was the traffic light red? That is a fact and issue. It's the main story. It's what the whole case is about. But if you ask an eyewitness where they were going that morning, and they say, oh, I was going to the bank, that's almost always a collateral fact. It might speak to their general credibility, but it's a side story. And under the finality rule, even if they're lying about going to the bank, you generally can't call the bank manager to prove it. So, how does a judge decide what's what? Well, they often use this classic legal yardstick known as Pollak's test. And what it boils down to is this question. Could you have presented this evidence as part of your main case, regardless? If the answer is yes, then it's not collateral, and you can bring in other evidence to challenge the witness. But if the answer is no, then it is collateral, and their answer is final. And here's a real-world example from a pretty famous case. A key witness was asked if he'd ever told someone that officials had offered him a bribe to testify. He said no. The court ruled that the defense lawyer could not call that other person to the stand to say, yes, he did. The conversation about the bribe was considered a collateral issue, separate from the core question of whether the witness was actually biased. But you knew there was a but coming, right? Like any good rule, this one has some major exceptions. The law recognizes that sometimes a so-called side story is so important to a witness's credibility that you just can't ignore it. The system has these built-in safety valves for fairness.
And this is probably the question that's been nagging you, right? So wait a minute, does this mean a witness can just lie about all these side issues and get away with it scot-free? Well, not if that lie happens to fall into one of several really important categories.
And these are the big ones. These are the 4 key exceptions where the finality rule just gets tossed aside. If a witness denies having a criminal record, or denies being biased, or denies that they said something completely different before the trial, you can bring in evidence to prove they're wrong. Same goes for showing they have a condition, maybe terrible eyesight or a mental issue, that means they couldn't possibly have seen what they claim they saw. These things are seen as so fundamental to a witness's trustworthiness that they override the rule. Okay, so let's zoom out for a second and look at the big picture here. What's the grand idea behind all these complicated rules and all these exceptions? Well, it's all about a very delicate balancing act. What this all really boils down to is that the legal system is not some perfect theoretical machine that's designed to find absolute truth no matter the cost. It's a pragmatic, real-world system. It has to constantly weigh that noble search for truth against the practical needs for fairness and for efficiency. And that brings us right back to that core tension. Everything we've talked about today is about managing this constant push and pull. On one hand, you have to avoid getting bogged down in those endless collateral issues. But on the other hand, you have to do everything you can to make sure the outcome is just and fair. These rules are the legal system's best attempt at walking that tightrope. And that leaves us with one last thing to think about. We all want our justice system to be both truthful and efficient. But as these rules show, sometimes those two goals pull in opposite directions. So the real question is, when you can't have both, which one should have to bend for the other? Thanks for joining me.